Before we start the program, I would like to give you some housekeeping information. First, we encourage attendees to use the computer audio feature of this webinar. During the program, should you experience any audio interference, such as static, intermittent audio due to a busy network, you can use the optional phone connection which is indicated on your screen below the webinar slide player. When using the phone for audio, mute the computer audio by clicking the speaker icon in the bottom left corner of the webinar slide player. Do not exit the webinar as your online attendance is being timed, and disconnecting from the webinar before the end of the program will prevent you from receiving CLE credit. Second, we will have a live Q&A session during the last 15 minutes of the program. You may submit questions at any time during the program using the Q&A function in the webinar interface. After the program, you can use the post-program question form to send program-related questions to the program's faculty. The post-program question form can be accessed from the program attendee page. Use the link provided in the confirmation email you received for this program to get there. Third, if you are seeking CLE credit, you must attend the entire program. Partial credit is not available. The ABA now uses an alert system for attendance verification. You are required to respond to verification alerts throughout the program by clicking Confirm to verify your attendance. Immediately after the program ends, a link to the program evaluation will appear on screen. Please take the evaluation to access the attendance confirmation and request for CLE credit. Some states also require that we collect your bar license number on the attendance form. Once the completed form is submitted and your attendance verified, your certificate will be emailed to you. A final reminder, this program is being recorded. To purchase a recording of this or other ABA programs, visit the ABA web store at shopaba.org or call the ABA at 800-285-2221. Welcome to Delivering Economic Impact Payments, More Challenges and Quandaries in the COVID-19 Pandemic Era, sponsored by the ABA, section of Taxpayer. Moderating the program today is Nina E. Olson, Executive Director at the Center for Taxpayer Rights. Nina, you may proceed with the program.
Thank you. Hello, everybody. I'm glad to be here today, and I want to just introduce the panel. Before I do, I want to thank Susan Morgenstern and the Pro Bono and Tax Clinic Committee for organizing this program, as well as many of the others that's really stellar programs that they have organized during our sequestering. I also want to thank Caitlin Hurd, the Center's intern from Harvard Law this summer. She's done a great job on the PowerPoint, and we are all really appreciative of her. We have a wonderful lineup today on the panel. Josh Beck, who is with the Taxpayer Advocate Service, Keith Fogg, who is from the Harvard Law School Federal Tax Clinic, Nancy Rossner from the Community Tax Law Project, and Caleb Smith from the University of Minnesota School of Law. The point of this program today, I'm just going to set up the program just a little tiny bit, is to say that, we all recognize how wonderfully the IRS has done in getting over 100 million of these economic impact payments out in unbelievably challenging circumstances, and all of us applaud the IRS for doing this. The point of this program is to talk about some of the challenges, both from the IRS perspective and also certainly from the taxpayer perspective and the practitioner perspective, as you're trying to assist people with the EIP payments and some of the difficulties and special situations that arise with these payments. And part of this is to maybe identify some things that if there is another round of payments, they could be addressed in that second round or elsewhere. So that is basically where we are. And I just want to note that right now we've got the notice that the IRS is coming out it has asked their people to show up. 11,000 employees are being mandated to come back, so we're seeing some progress in that regard. Just to give a little bit of introduction, the difference between 2008, when we had economic stimulus payments, and 2020, although the design of the payments were essentially the same, there are some changes from 2008 to 2020 that will have impact in some of the issues that we're talking about going forward. First of all, there is a global pandemic going on, and so unlike 2008, where you had the IRS fully staffed and operational, we don't have that now, and we certainly, the taxpayers themselves have challenges now that were not present in 2008. In 2008, we only had one look-back year. You looked at the 2007 income tax return to determine eligibility. Because of the timing and because of the pandemic, the law this year says you look back to 2019, and if there hasn't been a 19 return filed, you look back to 2018. And that has consequences for some of the challenges. And then we have just in this intro slide, we've identified, some of the things from 2008, TIGDA testimony and things like that, which showed that even in 2008, in the best of circumstances, the IRS faced a lot of challenges, that just special circumstances that showed up in delivering the economic stimulus payment. A lot of duplicate returns, a lot of injured spouse claims, and a lot of amended returns that came in that the Inspector General said the majority of them had been processed by the end of the year. November 29th was really the cutoff date for getting economic stimulus payments that year in advance. So we do have a few links here in the slides on procedurally taxing, where you can see some of the things that were problems that arose certainly in 2008. The payments to the deceased were a problem, and we'll talk about them a little bit more later on. And just with that as a background, I'm going to turn it over to Josh Beck, who's going to talk a little bit about, where we are, just to get us started off and understand exactly what the situation is before we start getting into the special circumstances. So, Josh, you want to take it away?
Yes. Hello, everyone, and thank you for listening today. And just as my standard government employee disclaimer, I just want to say that to the extent I have any original thoughts or ideas during this presentation, they are attributed only to me and not to the IRS, the Taxpayer Advocate, or the National Taxpayer Advocate. So with that, I just want to touch here on this first, on this slide, which is setting out the economic impact of the pandemic. And this really illustrates, Congress's push to get support out to taxpayers and, what was behind the pieces of legislation that they passed, and particularly the CARES Act, which contains the provisions for the economic impact payments. And I think the last number I saw is there's, since the beginning of the pandemic, there's been about 38 million unemployment claims. And, that is really the driving force here, is to get money out to taxpayers to help in this this crisis, this economic crisis that has been caused by the pandemic and some of the measures that have had to take place in order to mitigate the spread of the COVID-19. So next, as Nina touched on briefly at the beginning, there are some really distinct differences between the economic stimulus payment in 2008 and in 2020 in terms of the environment. As she said, largely the design, and I think to some extent, how we get these out to taxpayers, the playbook that was used is pretty similar. I mean, there's no sense of reinventing the wheel. But with that said, there's obviously new challenges. I mean, last time in 2008, the IRS was operational. We were answering the phones. We had a dedicated phone line for economic stimulus payments. We were opening mail. And just differences between the IRS's focus, too. We had taxpayer assistance centers that were helping with return preparation. And even though, in the next slide, you see taxpayer assistance centers are obviously closed, but even if they were open, they no longer help with return preparation. So, now it's a different world, as many IRS employees, have not been working, have been working at home. Some people that were working, that are working at home don't have access to IDRS, the system, the ancient system, older system, as we're all aware, used to monitor, to input information on taxpayers' accounts. They didn't have access. We weren't set up necessarily to answer phones remotely. So that poses a whole new set of problems, answering, opening mail and, all the correspondence that's just piling up. And as Nina mentioned, they're starting to reopen some of that, I'm sure with social distancing guidelines in mind. So, even so, like everything else, it's going to be a slow roll. Continuing with that theme of what happened in 2008, and I think maybe lessons learned or cautionary tales, is what the next slide is sort of all about. For me, there's a lot of information here about level of service, but when I was thinking about this, my takeaway was sort of, under the best circumstances in terms of having everything, of all the resources available for the IRS, they still were at a level of service for the year of 2008 on their phone lines of about 50%, which was about 30% lower than where they wanted to be. They still had a, average, speed of answer time of about double what they were hoping to be, about 500 seconds of wait time. The number of blocked calls, so that's calls that can't get through because the circuits are jammed, the queue's full, was higher. And the number of abandoned calls, people get tired of waiting, courtesy disconnects, so to speak, were also higher. So, as we move forward, everyone's aware that people need answers to questions, and there is an economic impact payment line that's open, as we'll see on the next slide, but it's going to be a struggle, to answer all those questions, to get the taxpayers the answers that they need. I think the other thing to be sort of aware of, a challenge for the IRS, is and I think this was the case in 2008, when you're plugging up one hole, when you're using something to plug up one hole, you inadvertently, create another one, and water's coming in somewhere else. And when you take people off phone lines or take people from other places to answer the phones, which sometimes is what has to be done, correspondence isn't getting processed, and that becomes aged, and there's downstream consequences that have to be considered as well. And we, as of now, like I said, there are some lines that are open. There's always the automated systems. There's the practitioner priority service line, the EAP line, but it's going to be, a slow process getting these up and running. And I also think the other thing is that when taxpayers, there's a lot of FAQs out there, as we all know, right? I mean, we've scoured these FAQs, been trying to find answers to all these questions. That's great. You're going to get people that call that don't have access to the internet. They don't know, they don't understand it, or their issue doesn't fall squarely within that FAQ. And, there will have to be a lot of thought given to how are we going to continue to answer those questions and make sure that taxpayers get the services that they need, or get the answers that they need, rather, and get the service that they deserve. Okay, so that's a little bit of a high view background. I mean, where we've been in 2008, where we are now, the challenges that lie before us, and what everyone's sort of thinking about, needs to consider moving forward. Now, the nuts and the bolts of the economic impact payments. This is a recovery rebate credit. It's an advancement, and it is a credit against tax for 2020. So last time this was done. This sort of the mechanics of it, of how it was written, is pretty similar to last time. This had to be reconciled in the, on the next year's return. So we don't have a lot of information on that, but I know this, we know this will have to be reconciled in some way on the 2020 return. As we'll talk about later, initially it seemed like if you got more, you wouldn't have to pay that back. It seems like there may be some exceptions to that. If you get less than you were entitled, you would be able to claim that additional amount later. Okay, so who is not able to get it? I think the important thing about this discussion is that Congress kept this pretty limited. It's non-resident aliens, it's individuals who have been claimed as a dependent on someone else's return, and it's estates and trusts. So, they kept it pretty statutorily, they kept it pretty small. And then the next slide sort of shows, well, there are other groups here that are not considered to qualify, even though it doesn't state that in the statute, and that would be incarcerated taxpayer, or people who are incarcerated, have been incarcerated, and people who passed away during 2020. And you can see the FAQs that address that, and we'll get into that a little bit more down below. There are also some other requirements. There's Social Security requirements. So all individuals on the return need to have an SSN, but there's two exceptions to that. One is if you file a joint return and one of the individuals on the return is a member of the armed forces, then one of those people can have an I-10, does not have to have an SSN. The other is for the qualifying child, they can have an A-10. I just wanted to point out here that, there's been a lot of discussion about this issue. If one person has an I-10, one person has an SSN, the children have SSNs, they filed a joint return in 2019, what can they do to get that EIP? Can they, file, a return now? Do they have to wait till 2020, filing separately? The other issue is if both parents have I-10s and the children have SSNs, then they are not they're not going to get that EIP. But I think, as many of you are aware, there's been a class action lawsuit that's been brought on that point, claiming that violates the Equal Protection Clause of the Constitution. So that will be interesting to see how that shakes out. Okay, so next, just the nitty-gritty thing here, which is the phase-outs. $75,000 for individuals, $150,000 AGI. This is for joint filers, and it's going to start phasing out. $5 for every $100 it exceeds. There's also caps. So if you earn more than $198,000 AGI for individual or for joint filers, then you wouldn't get it in $99,000 for individuals. There's one other thing I want to point out here in terms of the phase out. The way that that's applied is you add it together, the whole credit. So you add together the amount that the individual or the primary and secondary get, you add together the children, and then you start reducing the amount by how much the AGI exceeds those phase-out thresholds. Okay, so the next slide here is, when will the IRS get these out? Well, the statute says get them out, essentially get them out as soon as possible, right? Because that people need this money. So the IRS, to its credit, had done a great job doing that. As we'll see here, anytime you're doing something like that, you're getting payments out to the masses very quickly. Inevitably, there's going to be groups that have problems, because, there is so much that goes on for these to get these out behind the scenes. There's just the programming issues alone are really, really enormous challenges. So, the IRS really should be, commended for how quickly these have gone out. Okay, how much is it? It's $1,200 for individuals, $2,400 for the joint filers, and it's $500 per qualifying child, no cap on the number of qualifying children. And, just backing up here really quick, one thing I did want to point out, we talked about the phase-ins, phase-outs. One thing that I do think makes us a little different in 2008 too, is there were no, and it posed new challenges, was there no earning amount requirement. So, you can't get it if you exceed a certain amount of AGI, but you don't have to earn a certain amount of AGI to get this EIP. So that was really, we're reaching a whole different population that the IRS hasn't had that individual interaction with or touch with possibly. So, some of those issues will be discussed going forward. Okay, so how are people going to get these payments? Well, many of them and are going to get them, or most of them, I think, have gotten them through direct deposit. In terms of if you're going to receive it through direct deposit, that happened for the lion's share. Otherwise, you'll get a check or you'll get a debit card. Now, I think maybe people have seen some articles in recent days about the debit cards. I just know here in my home newspaper, the Des Moines Register, had an article that people didn't know what these were and they were just throwing them away. And the congressional delegation here in Iowa has reached out, I believe, this is what the article said, to the Treasury Department to see how they can get those reissued and if they're going to have to pay a fee to get those reissued. And the Consumer Protection Agency has written on the preloaded debit card issue. And I think, there are some good things about this, the preloaded debit cards. I think the one thing that this illustrates is, the challenges of doing outreach right now, and people didn't know what was coming, so there are definitely some challenges that have to be considered. Okay, so now in regards to decedents, we're going back to 2008 here. And in 2008, the FAQs said that if someone passed away after filing the return, and or a 2007 return was filed by a representative or a surviving spouse, the check would be made out into their name, and they would retain that. In 2020, the FAQ is different. When you'll see it here on the slide, can the person does this qualify? No. Here's what you need to do. You should send, the person who is receives this, whether it be a surviving spouse or whatnot, should send back the portion of the person who passed away. So I'll just point out that, we talked about who wasn't eligible in the statute. We went over that before, and that, these issues were not covered. And then secondly, I do think there are rather ambiguities or things to consider here with this FAQ, in the sense that if you passed away, on April 15th and you get your direct deposit on, April 16th, you don't get to keep it. But if you flip that around, you would, the person, in the estate or however that's managed would keep that. And I do think there is some, just kind of different situations that are going to come up here that, are going to have to be thought through carefully in terms how this FAQ sort of applies, to people's practical life circumstances. Because, it's possible that someone got ill with COVID-19 and passed away, and then this came up, this EIP, and here we are. Same issue with incarcerated taxpayers. The FAQ says to send this back. I will say here as well, I think there could be some applying this to sort of to the real world could get there could be some challenges or confusion. As many of us, we all know, many people or some people, to mitigate the spread of COVID-19 in our prison system, were let out on early release, depending upon their record. So you got your EIP, you were let out to mitigate the spread of the COVID-19 a week later. what happens in those situations? So those are just things that I think what this really illustrates. It's hard to apply really broad general rules, to every situation because, as we're going to see throughout this presentation, there's going to be little hiccups all along the road that are going to have to be addressed. So that kind of takes care of these slides on my section. I'll send it back to you, Nina.
Thanks, Josh. We had a couple questions come in. One question from Mary Gillum was, what about 17 or 18-year-olds who cannot be claimed by someone else and who are in state custody in 2019 or at the beginning of 2020? So obviously because of their age in 2020, they would be ineligible. If they were, eligible by age in 2019, the question is who's going to claim that person if they're in state custody? And I honestly don't know the answer to that. I don't know if anybody wants to chime in on this at any point. We can go back and find out.
Yeah, I don't know the answer to that. I will say that this just reminded me of something else that there, there was an issue with qualifying children, and if there's divorce, this isn't exactly the same, but it just made me think of this. If there's a divorce and one
right.
person gets it for 1 year, the other person gets it the other year, the IRS is not asking that those be sent back.
Right.
And I did just why I thought of that, wanted to distinguish that between some of our other conversations.
The IRS actually issued an FAQ recently that said that if you have unmarried parents of a child and each one based on, maybe somebody claimed it in 2018 and somebody claimed the child in 2019, each one got the $500 payment for that child, would they have to pay it back? And the IRS's FAQ says there is no requirement under the law to pay it back, which goes to the next question from Lawrence Hess that I think was delivered to me, saying that I wrote on procedurally taxing that I questioned the IRS's authority for denying the EIP to incarcerating deceased persons. I think that was someone else writing about incarcerated persons, but is that still the position? And I think, my PT blog was going about the deceased, was looking at the 2008 guidance, and the statutory language is the same from 2008 as it was in 2020. And in 2008, the IRS said unequivocally, yes, you would get the payment as a deceased person. And so my point was, what's changed? And where's your legal reasoning for why these people should pay it back, especially since all over the place in the FAQs, the IRS has said there is no obligation, there is no requirement to return an overpayment of the advanced rebate. So that's sort of where we are. Now, I think we've gotten a lot about, what about other incorrect and erroneous payments, and later FAQs say you don't have to return them, and that I think I've sort of covered that. And the IRS is looking at the dependent's age. A question was about the dependent's age. They're going to look at the 2019 return. If there is no 2019 return, then they look at the 2018 return, and it's the age on that return. And there is an FAQ that says, well, okay, my kid was, 16 in 2018, and I didn't file yet for 2019, and I've got a $500 payment for him. Well, I have to pay it back. And that's one of the FAQs where the IRS is saying, no, there is no requirement to pay back, these things. Okay, let's go on for a minute. We'll catch up with some more of the questions at the end. I think, Keith, this is you. We're going to talk about actually for those people who needed to update some information and were below the filing threshold.
Okay, thanks, Nina. Before I jump into this slide, I'm going to just take us back into the deceased and the prisoner issues a little bit, just to say that I think Josh was giving us the position of the Internal Revenue Service, and so there isn't total clarity on why a person receiving a payment that for a deceased person or a prisoner receiving a payment must pay it back. The statute doesn't require that. And I think that we're going to see some litigation over those issues. It'd also be curious, and we didn't talk about this, in terms of how the IRS would go about collecting the money back. So I think there's a lot of uncertainty in that area, and I just wanted to highlight that before we moved on. So I'm going to talk about the system that the IRS set up to try to make sure that it made the EIP to every person who qualified, because the IRS knew that a lot of people don't have a return filing obligation. So if it was going to base the payments on picking up information off of tax returns, and there were a substantial portion of the population that didn't have to file a tax return, it needed some mechanism to bring that group of people into the system so that it made sure that they received a payment. And to do that, it set up what it calls is a portal for these individuals who otherwise wouldn't have a return filing obligation to submit information to the IRS so the IRS knows about them and can make sure that they get the EIP the same way that somebody who filed a return would get an EIP. And that's why it did this. And so then we talk about the why, then we begin to talk about the how. But before we get all the way past the why, there began to be questions to the IRS like, well, why are you going to make the people who receive Social Security benefits use this portal? Why can't you just walk over to the Social Security Administration and get the data from them on who they're paying? And not only will you get their names, but you'll also get their banking information in most cases, because the Social Security Administration is dropping the monthly payment into a bank account that you the IRS could use. And so not too long after the IRS came out with the portal, it kind of walked back a little bit and said, okay, if you're getting Social Security payments, we're going to go over to Social Security and get that information. You don't have to use the portal. Then other people were saying, well, why can't you walk over to the Veterans Administration? Why can't you go and get the SSI information? And so a couple of weeks after that, the IRS said, okay, we'll go over to the Veterans Administration and we'll get the SSI information, and those people won't have to use the portal. So for a lot of individuals who don't file tax returns, the IRS is going out to these other parts of the government to get information to allow it to send out the EIP without having to require that individual to file something through the portal. And keep in mind, Josh not only talked to you about, there's no TAC at the IRS to help these people, but there's also no VITA sites and no AARP sites, because the pandemic shut down these free filing sites that would ordinarily be available to individuals who need assistance in preparing returns or to answering questions, something like the portal. So the more people that the IRS can serve without requiring them to go to the portal, the better, because the resources for a lot of people who would be challenged aren't available because of the circumstances that we're in. So now we talked about who doesn't have to use the portal based on the IRS going out to Social Security and VA. But there are still a lot of people who don't have return filing obligations, who don't get Social Security or don't get veterans benefits, who need to let the IRS know, hey, they need to raise their hand and say, I would like to get an EIP. So that's what the IRS has done in creating the free file portal. So then the next question could be, well, what is it that I'm filing when I submit something on the free file portal? Let's go ahead and go on to the next slide. Okay, thanks, Nina. And there, you're asked to fill in a lot of information that looks a lot like the information that you would fill in if you were preparing a tax return. So does this thing that you're filling in at the portal, is it a tax return for 2019? Does it meet the Beard test? There's those of you who are familiar. There's a tax court case from the 1980s by the name of Beard versus Commissioner that sets forth a 4-part test that's been widely adopted as the test for determining whether something is a return or not a return. And if you look at the Beard test and you look at the information that's being requested of the individuals who are on the portal, it seems that it meets all of those tests, including that the individuals are required, as they complete the portal, to sign something under penalties of perjury, which is the fourth of the Beard test. So it seems like, although the IRS doesn't describe this as filing a 2019 return, that the person using the portal may be filing a 2019 return, at least, and something like a 2019 return, if not a 2019 return. So who is supposed to do this? So the description of who is supposed to use the portal is a little bit cryptic, and there's a good reason for that. I mean, it's unbelievable what the IRS did in such a short time to come up with this. I mean, you had the pandemic coming out, and then you had the Secretary of Treasury saying, we're going to send out checks in 3 weeks. And so they created this portal practically overnight. So it's not surprising that there would be some glitches in the system, but they deserve high praise for pulling this off. But they talk about people who make less than $12,200 if it's an individual, or $24,400 if it's a couple. But when it's asking those questions at the front, it doesn't mention self-employment tax. It also doesn't talk about people who make less than that and who might not need to file a return, but who might want to file a return, such as somebody making $12,000 who has qualifying children who wants to get the earned income tax credit or the additional child tax credit. So there are some issues with who will be, who should use the portal, and what happens if you do use the portal. So you're using the portal as a mechanism for getting EIP, but it's not the mechanism for getting your tax refund. So it could be that you could be getting, a not insubstantial EIP, but still much less than the amount you would get on a tax return if you were entitled to a refund involving the earned income tax credit and the child tax credit. So if you use the portal, it in a sense it uses up your one electronic filing for the year, and then if you needed to file a tax return, you'd have to file it by paper. And if you're filing a tax return by paper during this filing season, your tax return is going to a trailer somewhere on a service center site, which may not be processed for quite some time. So you might end up using the portal to get a quick payment of the stimulus payment, but at the same time significantly delay the payment of your tax refund. So you have to be careful about how those two things interact. And the IRS received comments from the American Bar Association tax section and others about the fact that this portal payment may be stopping somebody from filing electronically later, and could they fix that? And they've indicated perhaps they are working on that. But just be aware that's a major issue. The portal also is limiting in terms of the filing status you can use. You can use married filing joint or single, but it wasn't set up to do married filing separate, and that can be an issue. And we'll be having some discussions about some of the marital issues that are implicated in this pandemic. So those are things to be aware of regarding the portal and how it sets up and how it works in this environment. And here you see a slide that's talking about how is the payment posted. So I remember Josh or maybe Nina talked about this is an advance payment. So they're building on the same thing that they did in the crisis a dozen years ago. They are making the payment now, but it's an advance payment on a tax year that hasn't come to a close yet. So the payment is going to be posted to the taxpayer's 2020 account. If you're familiar with the way the IRS maintains its accounts, each tax period and each type of tax is a separate account at the IRS. So they will already create a 2020 tax account for the taxpayer, and then they will post this payment as a credit having been paid on that account. And then when the taxpayer goes and files their 2020 return, there'll be a reconciliation. Because of the way the statute's written, it's indicated that when you make that reconciliation, if the taxpayer was overpaid on the EIP, they don't have to repay it because of the way the reconciliation will work. But the question then arises, and this slide illustrates what happens if you got an EIP payment of $1,200 for yourself, but you were also entitled to a payment of $500 for each of your children, and you had one or more children. How can you go in through the portal or through some other mechanism and accelerate the payment of the $500 for each child in this time period, with in the spring or summer of 2020, or must you wait until you file your 2020 return and only get the payment for those children sometime next winter or next spring? At present, once the IRS makes the payment, it appears that that's it for the year, that they're not going to supplement that payment with additional payments to taxpayers. I think there's pushback from the ABA tax section, the AFCPA, and others, but that's the way that it sets up today. So there are some slides at the end of this section, as you can view, that link you to some procedurally taxing blog posts that talk about the way the EIP payments work and in certain circumstances, and I commend you to view those blog posts if you haven't already. Thank you.
Thank you, Keith. I think that really sets up nicely the next section, which is you sort of discussed some of the issues where either through use of the portal or whatever your circumstances, you may want to file what's known as a superseding return. And so Nancy Rossner is going to talk about that next. Nancy, you want to talk about it?
Great. Thank you, Nina. So moving right into what is a superseding tax return. A superseding return is a tax return that is filed after the filing of an original return, but before the tax return filing deadline. The IRS will treat the superseding return as if it was the original return. You will find support for this treatment of the return in the IRM at 21.6.7.4.10, but there is an important note there. If the purpose of the second filed return, the superseding return, is to change the filing status from married filing jointly to married filing separately, it must be filed on or before the due date of the return, even if a timely extension has been filed. So this is in contrast to other superseding returns, which are treated as superseding if filed on or before an extended due date, that they're being filed to change items other than the filing status. So that is an important note to keep in mind. The concept of a superseding tax return is not a new one. It dates back to the 1940 U.S. Supreme Court case of Hager Co. v. Helvering. And with that, I think Keith is going to jump in here just to give you some background on superseding returns from that case.
Nancy. It was a case in which the taxpayer made an election, and then before the due date of the return realized that the election they had made was not the best election, so they filed a new return making a separate election. And the IRS ignored their new return, saying, we don't have to pay attention. You filed one return, that's all you get. You don't get a chance to file again. And the case went up all the way to the Supreme Court, and the Supreme Court said no. You must file a return before the due date, but if you decide you don't like the return you filed at first, you can file another return. If you do it before the due date, that new return becomes your return for the year. And ever since that Supreme Court case, the IRS has acknowledged in its manual and in its guidance to its employees that subsequent returns filed by a taxpayer before the due date of the return, must be accepted as the return of the taxpayer.
Great, thank you, Keith. So next, the important question is why file a superseding return? Superseding returns have become increasingly more important with the pandemic, the CARES Act, and the issuance of economic impact payments, or EIPs. For individuals, we have identified two very important reasons for filing a superseding return in this context, though there are many others. But the first addresses the issue arising from a taxpayer who is not a member of the armed forces, filing a tax return with a Social Security number, but claiming a spouse or a qualifying child with an ITIN. Under the CARES Act requirement for a valid identification number, which the Act identifies as either a Social Security number or an adoption taxpayer identification number, no one on the tax return would be eligible for an EIP. So in this situation, the taxpayer with the Social Security number, who may have already filed an original return but claimed dependents or a spouse with an ITIN, can evaluate whether it would be more financially advantageous to file jointly nonetheless, so to go ahead with the joint return and not really worry about not being eligible for the EIP, or instead to file a superseding tax return so that only the taxpayer with the Social Security number and any children with a Social Security number are listed, which would ideally trigger the issuance of an EIP. So in this situation, the practitioner or the taxpayer would definitely need to do an analysis of whether a married filing jointly or separately would produce the most refund or relief to the taxpayer while also taking into account the EIP. There are certain benefits and credits that are only available to married filing jointly taxpayers, so it's not going to be just a simple, straightforward answer. The second reason that a superseding return may be more important during this time has to do with taxpayers who filed married filing jointly in 2019, but who are no longer together. So this can include, in some situations, taxpayers who agreed to separate and divorce, or in other situations, taxpayers who fled an abusive spouse, possibly with children in tow. In both situations, it is only the primary taxpayer or the first taxpayer that's listed on the tax return who will be issued the EIP. And generally that's using the bank account or the address that's listed on the tax return filed. This includes situations where the taxpayer filed jointly and used Form 8888, which is a form that you can use to direct your refund into different bank accounts. So even in situations where the taxpayer is clearly meant to split the refund into two separate accounts, the refund will be deposited into the first account listed. We have seen this anecdotally at our clinic, and you can also see that addressed in the IRS EIP FAQ number 33. So what we are seeing at our clinic and hearing from local and national organizations serving victims of domestic violence is that the EIP is being deposited into the abuser's account, and then the abuser is refusing to release the victim's portion of the EIP to the victim. I do want to point out that under Section 6428E2 of the CARES Act, in the case of a refund or credit being issued with respect to a joint return, half of the refund or credit is treated as having been made or allowed to each individual filing the joint return. So the whole EIP does not belong to the primary taxpayer. Rather, there's the portion that belongs to the primary and the portion that belongs to the secondary taxpayer. So in this situation that I've outlined here, a taxpayer may want to consider filing a superseding tax return to instead file separately for 2019, despite a married filing joint return already being filed for 2019. And that's with the hope that it would preserve their separate right to their own EIP. The relief provided by the IRS as a result may not be seen until late 2019 or 2020, when the IRS eventually processes the superseding return and hopefully issues the EIP to the spouse who never received it. The CARES Act itself does not prohibit the IRS from issuing more than one payment. However, Section 6428H does provide the authority to the Secretary to provide regulations or other guidance to avoid allowing multiple credits or rebates to a taxpayer. So I think we had a question that is relevant to this topic, having to do with how do you file your 2020 return if the EIP was already issued based on a joint 2019 or 2018 return, but one spouse isn't giving the other spouse their portion of the EIP. So my perspective as a practitioner would be to file the 2020 return. In my opinion, it would not be appropriate to list that you had received the EIP if you didn't actually receive it, and instead attach a statement addressing that situation and explaining that the EIP was issued to an account to which you did not have access and therefore you didn't receive it. There may be some concerns with, math error or penalties being issued if you're not reporting the credit. So I do think it's important to address it maybe in an attachment in the hopes of avoiding that. But once you claim the credit on the return, I think it's going to be really hard to backtrack and say, no, actually, I didn't receive it. So from a practitioner standpoint, I think that is what I would advise in that situation. Of course, it's yet to be seen how IRS is going to treat those situations. And then I think as another practice point, where it's possible, the taxpayer should try to work this out on their own, if possible, through divorce proceedings, a separation agreement. If they can work that out in the agreement, then it might be a little easier or more straightforward than trying to get the money from the IRS, because at this point, we're not sure if the IRS will be issuing another EIP in this situation. So how do you file a superseding tax return? It's generally going to be filed by paper, and there's a link there on the slide for where to file the return. It is advisable to write in big, bold letters, superseding return across the top of the tax return. And I would even go a step further and also denote the relevant IRM provision, which again is 21.6.7.4.10. Because we have heard from other practitioners that the IRS may not always understand or note that it is a superseding return and should be processed as such. And in the unique situation of an original return being filed by paper instead of electronically, and then the superseding return is being filed electronically, I would recommend doing an attachment to the return if your software allows it, indicating that it is a superseding return, and again, citing the IRM provision. So that way you're still identifying the return as a superseding return, because as we know, IRS is not processing paper returns at this time. And it's very likely that an electronically filed return may be filed sooner than a paper filed return that may have been filed several weeks ago. Yes.
Yeah, so we did get a question, and I wanted to address this question, and then we can go through some of the slides with blog posts. But we did get a question about if you are a beneficiary recipient who missed the deadline to claim your child through the non-filer portal, is there any risk harm in trying to e-file through IRS Free File a regular 2019 return claiming $1 and other income for EIP purposes and checking the box for child tax credit to get the $500? Now, I'm going to sort of weigh in here, go a little bit out on the limb. My understanding is that for the IRS to have generated these automated payments, these automatic payments to Social Security, SSDI, SSI, et cetera, it basically had to create a dummy 1040 return. If you remember that IRM manual provision that said, it will create a return with $1 taxable interest, $1 AGI, gross income, $1 AGI. I think that's what's going on behind the scene. So you could try to do it with Free File, but I think what you will get is the message that there's already been a return filed, and so that's where you would have to go to the superseding return. Just in the interest of time, I'm just going to have us pass through some of the blogs that both Keith and Nancy have written about superseding returns, particularly in the spousal abuse area, and also the National Taxpayer Advocate issued a blog a couple of weeks ago about superseding returns, and Brian Camp talked about something on TaxProf blog on some of the tax court lessons about this. So sort of moving on, we're getting a lot of questions about, facts and circumstances, but maybe, Nancy and Caleb, you could talk just for a couple of minutes about, what people are seeing in VITA sites, because some VITA sites are open and they are trying to do virtual VITA. So I'm not sure who's going to start. Is it Caleb?
Sure, I can talk a little bit about what I've seen, and Nancy, you can chime in too. So, just as the general state of VITA, the organizations I've talked with are struggling because they have to do pretty much everything remotely, and a lot of times they're working with populations where that's not particularly feasible. So you've got the kind of mechanics issue of how do we help people generally. That's something we're all struggling with, but I think VITA, which relies heavily on in-person volunteer preparation, is dealing with even more. And those, what I've heard mostly from VITA organizations are, for people with the non-filer tool where that applies, you can sometimes help walk them through online, assuming they have online access. But for so many people other than that, and Keith actually touched on one, which is for married filing separate individuals, where you really need to prepare a return, walking people through that, unless you have something remote set up where you're both seeing each other's screen, is kind of beast that a lot of people haven't been able to work with very well in the VITA world that I've seen. And they're still, trying their best to, help these individuals, but it has been quite a battle. So that's kind of the mechanic side. I've got other on the substantive side, but I want to pass it back to Nancy to her input.
Sure. I think we're seeing a lot of the same issues locally. Some of the biggest challenges, especially for the low-income filers, which are often the people using VITA, is the access to technology. So they need to be able to use some sort of smartphone or computer and scanner so that they can send the information to the VITA. And then we're also seeing some distrust, too, of doing the process entirely virtually. So we're also getting some feedback from that as well at the local VITA and AARP sites, that some people are more comfortable sitting down in person and doing the process that way. So that's definitely pose some challenges. And then I think as far as other issues that we're seeing, one of the issues that I touched upon earlier, EIP being deposited into an account to which the taxpayer doesn't have access, whether that's because of a divorce or separation or identity theft, which I think we'll touch upon later. And then just the general issue, trouble and inability to use the IRS online portals. So what are some of the issues that you're seeing there, Caleb, as people are actually trying to go through the process of filing these returns?
So a couple of things. One, for individuals that more or less have to send in returns by paper, that's a huge issue for a lot of reasons. It normally takes a long time for the IRS to process in the best of times. These are not the best of times. So there's any number of reasons why you might have to file by paper. Again, married filing separate comes up. If you don't have your spouse's social security number, a lot of times you can't file electronically, so you need to know that, which can be tricky. But the biggest issue that I've been dealing with, a lot of times, thankfully, VITA is able to answer the simpler questions, but the one that I've seen persistently, and it's a substantive issue, is injured spouse. Cases where the economic impact payment is getting offset for one spouse owing back child support. That has been the number one issue that I've seen, and the IRS is aware of it. And I think with that, we can kind of, unless, Nancy, you have anything else you'd want to bring in, we can move into...
No, that's great.
All right. So we can advance to the next couple slides.
Coming slow.
So, yeah, as I mentioned, and kind of from the outset, when the CARES Act was passed, practitioners and tax attorneys and professors were poring over the CARES Act and saying, here's all the potential issues out there we think might happen. And some of them were hypothetical. How is the IRS going to interpret this? How is the IRS going to interpret that? One that I've seen on the thread of questions, for instance, is one that is still, as far as I'm concerned, kind of up in the air, is how do we work with, or what happens on a tax return where the primaries both have Social Security numbers, but a qualifying child or a qualifying relative on the return have an ITIN? Does that ruin the economic impact payment for everyone? And those are the sorts of issues that you have to just kind of look out to the community and see, how is that actually gone about? Is that an actual problem that we have to deal with? Is that something that's going to be litigated? And that you just have to get basically feedback from the community. I will say, actually, anecdotally, because I saw this as a question, so I wanted to address it. There's the issue of whether or not, there's the question of whether or not a qualifying relative, so not a qualifying child, but a qualifying relative with an ITIN on a return will ruin basically the EIP for everyone. And from the VITA site that is in my area, the largest one, they told me that they've had a few people with that situation where they have received the economic impact payment. So anecdotally, at least, it might not be a problem. So just throwing that one out there. But there are issues that we have seen come up in practice that maybe we didn't actually think were going to be, necessarily a problem with the CARES Act. And the biggest one that I've seen just frequently and received a lot of inquiries about is this offset for child support. So the EIP is pretty generous in that it's not offset the way prior wasn't EIP, but prior 2008 offsets, would work. So now there's pretty much no offsets except for child support under the Act. And where that comes up, and I just want to make a quick mention actually on the first bullet point before I get into that. The exemption from offset loses its protection once in the taxpayer's bank. What that's really getting at is this is a concern that other people have had. There's no offset, but if you have the money deposited in your bank account and you have a judgment creditor or whatever, and they can take out of your bank account, there's questions about whether or not that money is protected. And there have been, bankers associations wanting more guidance on that. There have been Congress people saying, let's have a specific protection for the EIP. But right now, from my understanding, it's really a matter of state law whether or not a judgment creditor could come in and take the EIP. But that's not an offset. That's a levy. The offset issue, just to give kind of high level for what it is for people who might not be familiar with injured spouse, you have two people filing a joint return. One owes back child support and the other does not. What happens? Well, if the IRS might take all of the money and put it towards the person who owes the child support, leaving the other one who doesn't owe anything out in the cold. So there's a mechanism to fix that, which is called injured spouse. And the way that the CARES Act is set up is such that it should work where the EIP is basically split in half. So you have two different people. You always have to have a joint return for injured spouse to work. And they split the credit right in half. So the one spouse that owes back child support, their half goes to the back child support, but the other who doesn't owe it, well, they get it. That's the way it should work. But that's not the way that it has worked. And the IRS is aware of this. This came to me, and it was a SAMS issue that's been posted, and actual congressional liaisons in my area were asking me about it. And the IRS put up an FAQ. It was 31. I actually think it got bumped to 32 now, where they spotted the issue and they said, look, if you filed injured spouse with your 2018 return or 2019 return, if that's, the more current one that they're going off of, we will fix this. Just give us some time, essentially. And we're sorry for the delay. We will fix this. The question is really whether that's happening. And that should have happened from the offset. So kind of moving to we're on the right side now. This is not an issue that could be unforeseen by the IRS. 2008, you had, injured spouse isn't new to this. And in 2008, the IRS had similar guidance. So it seems largely to be, to me, kind of a mechanical issue and a systemic issue within the IRS of just getting it to work, and that they've said that they're going to fix it. We can go forward to the FAQ that deals with it. But does that FAQ deal with all of it? The FAQ, as I kind of mentioned here, is basically saying, look, we're aware of this and we're going to fix it. But you have to be, cognizant of who this FAQ really applies to. It's saying if you are married and filed jointly and filed an injured spouse claim with your return, then we're on it. But there is a large class of people to whom that does not necessarily apply. So I'll go ahead and jump over to that slide because I think that's kind of the meat of what's happening here. So who would that FAQ not help? Most obvious are people who didn't file a Form 8379 with their return. And there's any number of reasons why that would be the case. If you weren't due a refund on your 2018 or 2019 return, because guess what? I mean, the EIP wasn't going to be on it, you don't file an injured spouse return or injured spouse form. You only file that if you are due a refund and one person owes a back tax debt, liable for another debt, and you are not liable for it. So right there, people who weren't due a refund, they weren't going to file an 8379, so they're out of luck. They have to file one after the fact. Similarly, you don't file an injured spouse form if, there's two spouses, one of them had all of the income and all of the credits are attributable to that person, and that is the person who owes the debt that's going to be offset. It's not usually on the injured spouse just this neat little split in half of, oh, here's the refund, half goes to this, half goes to the other person. It's usually looking at who is it actually attributable to, and there's some nuance there, but that's generally what it is. And then the third one, and I think this one's actually pretty critical, is there's a lot of people who just don't know of injured spouse generally. I volunteer at VITA, and it's always, kind of a thrill when you can tell people that they're filing jointly that this is something you can do. And there's a lot of people who are unaware of it, so they just might not have filed. Now, the issue there becomes one kind of split into two. One is practical. It's really how do you actually prepare the form, and then how do you actually remit it? There's not really much guidance that I'm aware of at this point on how you'd actually fill out the Form 8379. So if you're looking at it, and one of the first questions it asks is, what year does this apply to? Well, arguably 2020, but that tax year's not done yet. What do you do to fill that in? My assumption and my hope, frankly, is that the IRS has some very streamlined, here's how you fill it out for the advanced, for the EIP basically, because it doesn't sync up very well if this is filing with your 2019 or applying to your 2019 return that you already filed. The numbers aren't going to work very well. Some of these can probably be answered pretty quickly. One of the bullet points is if dependents are involved, how do you allocate the $500? The EIP should be split in half. But again, it gets to a question of what year. In the IRM that is on point, and again, I don't think taxpayers out in the public are just going to be looking at the IRM. It's tricky as a practitioner. The IRM on point isn't particularly useful, so there isn't much tailored guidance to how you actually fill out the form. Second part that's really critical here is, okay, now you've got the form filled out. You've done your best with it, or maybe it was simple for you. How do you actually send it? Now, if you've already filed your return electronically, you cannot send the standalone Form 8379 electronically. It has to be done by mail. And there's a concern right now, and hopefully it'll be alleviated a little bit with more people going back into IRS offices. But you send in something on paper right now to the IRS, how long is it going to take for them to actually process it? That's assuming you filled it out right in a way that they can process it. But under the best of circumstances, usually they advise 8 weeks of processing times. I'm going to say that that's probably, barring some sort of special processing center for it, 8 weeks sounds optimistic to me. So there's really this big issue, and this is not just for injured spouse forms. This is for anything that has to be sent on paper right now. When is it actually going to get looked at? Because this is money that people need, right now. And I wrote a post on this that brought up the issue as it was brought up to me, and there have been a lot of comments on it, and I get a little message every time a comment comes up. So there are a lot of people in the community that all pretty much are saying the same thing. I need this money now. I tried calling, the county, the child support service agency that took the money, and they say you have to go through the IRS, or there's conflicting information, but one way or another, they're not really able to get it. So it's a huge issue. And I think in the interest of time, I'm going to put off there.
We're getting a lot of questions, and I just want to spend just a second before we go to the next section, which is about innocent spouse, which will answer a bunch of people's questions, to remind people the mechanism that the EIP that you are getting in 2020 is actually an advanced payment of a credit that you're going to take against your 2020 income tax you're going to claim on your 2020 return when you file in 2021. So that's the first thing. The second thing is that in order for the IRS to get these payments out as quickly as possible, it is my understanding that it had to utilize its regular submission processing system. That's why it's creating behind the scenes all of these things that look like a return, whether it comes through a portal or it's an automatic payment or whatever it is. And so once there's an electronic return filed, for you to claim the credit, whether it's for a dependent child that you missed the deadline for, or you don't have an injured spouse form on file and you want to get your share of that EIP, you're going to have to do something more. And Caleb has gone through, how difficult it is right now in this environment to get an injured spouse form applied. Nancy has talked about the superseding return, and we're all going to talk toward the end about, you can be going to you can file a superseding return. Getting it processed is another thing. And if the IRS takes the position, if you've already gotten an EIP and we're not going to pay out a second one, for example, to dependents, then you're in a position of having to litigate that. That's the IRS's position. And I think it's not the law. I think what it is it's a determination based on the way they're processing things, which in my opinion should not be guiding us, but we're in a coronavirus situation. So maybe the next thing then, let's turn it over to Keith, and I think Nancy's going to chime in here, if we can get the slide up, to talk about spousal abuse.
Okay, thanks, Nina. This slide, there's not going to be a lot of happy news here, but the slide is pulling from a letter written by the tax section on May 12th of this year to the commissioner, talking about some issues that have been identified with EIP and with spousal abuse, and not only identified by members of the tax section, but identified by members of the community of practitioners who assist the survivors of domestic violence. So what you see on the slide is a series of recommendations that were being made to the IRS on how it might consider dealing with this situation. But I had a client contact my clinic whose domestic violence incident occurred in 2020, and because everybody's living in close quarters, there may be many domestic violence incidents occurring in 2020. So how does the IRS deal with that? How does it unwind what would have been on a return? How does it do that when nobody's home at the IRS? So that's what this slide is kind of highlighting, some of the issues that have come up and suggesting possible ways to work through it. But it could be that this is going to, like other things that we've discussed today, it could be a very slow work through for people who are very desperate for funds at this time. And Nancy, I'm going to give you a chance to talk a little bit about the process of coming up with this information.
Sure. This information was pulled from meeting with other national and local agencies that are assisting survivors of domestic violence, also in talking with other tax practitioners on what they're seeing. But I think a lot of these issues were anticipated as the CARES Act was coming out, that a lot of these groups were sort of activating and saying, we know this is going to be an issue. A lot of survivors may be unbanked, they may be living in shelters, and this stretches beyond survivors of, spousal abuse and domestic violence. There's homeless that sort of fall into that same category where they may not be able to access online portals and they may not have filed a return in quite some time. So they're going to have a lot of trouble getting the EIP. But these are very vulnerable populations that definitely deserve attention. And it's great that the ABA tax section included that in their letter on May 12th. And there's also, some of these national domestic groups representing survivors of domestic violence, like the National Network to End Domestic Violence, and other congressional offices are writing letters to IRS and Treasury to address these specific issues and ask for a fix. Now, some of these fixes will be extremely important as we look ahead and if there's going to be other rounds of stimulus payments. So, the concern is not just the EIPs that have gone out, but if there's going to be EIPs coming out in the future, we obviously don't want those to going to accounts to which we know the taxpayer's not going to have access. So I think as advocates, we will definitely need to do our best with what methods we have available to us right now, and whether that's working with these superseding returns, or if that doesn't work out quite like we're hoping it's going to, it's going to be attacking invalid joint returns, working through requesting innocent spouse, or working with the family courts to try to address the EIP as the taxpayers may be getting divorced.
Okay, thanks, Nancy. That's all I have for this slide.
Okay, I just want to let everybody know that the ABA tax section's Pro Bono and Tax Clinic Committee is going to be doing a separate webinar on domestic violence, spousal abuse, etc., so that these issues will be going into much more detail and other issues that would come from this. I did also want to mention some of the questions that came in were about this offset issue. The statute specifically says the EIP payment itself can't be offset against like any other tax debt or the state tax debt under the Treasury Offset Program or the Internal Revenue Code, except for child support. But once the money goes into a bank account, it can be offset unless it goes to the Direct Express card, which is the card for federal benefits like SSI and SSA, et cetera. Josh mentioned a while ago the Consumer Finance Protection Board had issued I think it was a regulation that declared that the EIP was not a federal benefit, and what that led to was Treasury being able to negotiate this debit card that we mentioned for the EIP. But a downstream consequence of that was, by saying it's not a federal benefit, it made the EIP eligible, able to be offset by other debts once it landed in a bank account. Now, Senator Grassley and Senator Wyden have sponsored a bipartisan bill to protect the EIP from offsets once it lands into the account, and we should all be watching very closely the progress of that bill. And also, this is a lesson for if there is another payment or any kind of payments going forward, that is something that we want particularly in the language of any statute. So now, Josh, why don't you take just a few minutes, not very many, to talk about, what might happen what might delay the EIP really if your return is caught up in the identity theft filters, the refund fraud filters, or there is return preparer fraud.
Okay. So some of the EIPs landed in, because of return preparer fraud, landed in, accounts that weren't theirs. That my understanding is that shouldn't have happened in the first place, because when the EIP went out, the bank was to verify that it was a taxpayer's account, and then if it wasn't, it was to be sent back. But, as we've talked through this, there's been glitches along the way, and that's one of them. Those taxpayers who have not received it because it went into another account or a mistaken account need to file an identity theft affidavit, form 14039 with the IRS and write EIP at the top. Now, as we've said, I'm a broken record here. They're going to a campus that's not fully operational, so we don't know how these are going to get processed. But, that's what needs to be done as of now. In terms of identity theft, if the taxpayer has an identity theft indicator on their account, the EIP did not go out. So that identity theft issue is going to have to get resolved before the EIP can go out. If you think you've been, you go to file on the free file system or anything like that, or, even if someone went to go file on the portal and someone used their information and filed before, it wouldn't let you file or on free file, whatever the case may be, you think you've been a victim of identity theft, you need to, file the return and then file the form 14039. Now, I think that causes, some issues. As we've mentioned before, someone asked about the efile return. So how's that going to play itself out? But they really, will need to file, the identity theft affidavit and write EIP at the top to get that process. Now, and some of this is still, just this week, the IRS updated some IRMs on identity theft and some of these issues. So some of this is still, processes are still being worked out. In terms of refund fraud, if your return, the way that works is, income or wages cannot be verified. So your return may be selected for screen for further review. So either we don't have the information at the IRS from SSA, we don't have the data to match it, so we're going to hold on to it till we do, or there's a discrepancy. If it's being screened, the EIP still went out. But if the IRS made a determination that the income or withholdings could not be verified, and they've referred it to another IRS treatment stream, so such as exam or someone like that, a treatment stream such as that, that will not be, the EIP will not be sent out. And again, such as identity theft, that issue is going to have to be resolved before that EIP go out. So the EIP is sort of ancillary to the larger issue, and you got to get that larger issue resolved to get that EIP unlodged. So in a nutshell, that's, as how to deal with those issues as of now, and perhaps there'll be more guidance.
Okay. I think what we've learned, and certainly we're seeing this in all the questions, is, all of the variations. And if you recall that what we started with was, where are the approaches for the complex situations? And so now we're sort of going to go into a discussion about, well, now, given all these situations, what's a person to do? What's a representative to do? Before we get into that, I did want to acknowledge a couple of questions. There were several questions about, disabled adult children. And this is an explicit omission from, in the Act, that there is no provision for this dependent disabled adult child who's over, who's 17 or older, for getting an EIP for that. And I think, again, as I've mentioned, this is an opportunity to really raise this to Congress if they're really going to do another round of payments. It's sort of inexplicable, but there you go. There was a question about depositing the payment into the wrong bank account. And whereas maybe a little bit ago I would have said, the only way that there'd be a deposit in the wrong bank account is, there are all sorts of variations. It could go to the bank account of a former spouse that was once jointly owned, but it's not yours anymore. Is that a wrong bank account? It could be, and I've heard instances of it's actually the wrong bank account, like somehow the IRS system screwed up. And that's where the difficulty of not being able to reach anybody is profound. And that leads us maybe to the next question, can TAS assist in situations like that? TAS had issued an interim guidance memorandum saying that it was not going to be able to assist with EIP cases only, that maybe if it was an identity theft type of case and the identity theft was holding up the EIP, they would be able to assist. Josh, do you want to talk about that?
Yeah, so, I think those examples that we just walked through with return preparer fraud and identity theft would be situations in which TAS would work the primary issue to get that EIP sort of unstuck and get it out to the taxpayer. So you have the identity theft indicator on your account, whether you need to authenticate your identity, whatever the taxpayer needs to authenticate the identity, whatever the case may be. We work that issue, get that indicator off, the EIP goes out. We work with you. The IRS made a determination that it can't verify your incomes or wage, withholdings. We could work with you, the taxpayer, to get that resolved. It would, help move that EIP along. I think the issue right now, at least part of it with the EIPs, is that there are not a lot of processes on the IRS's side on how to work these cases. And, I think that it was hard to take the cases in when we don't know, how these are going to be worked in TAS. With that said, just because we're not taking in the sole issue, a case where the sole issue is EIP, it doesn't mean that those issues aren't being worked. For instance, the injured spouse issue that Caleb talked about, earlier, I know that a number of folks in our systemic advocacy group have been working diligently, on those issues. So, a lot of these more systemic issues that are coming up, we're working with the IRS to get those resolved.
So one point that I wanted to make just as a reminder, even in the best of times, remember that very early slide we had at the beginning, that even in the best of times, like 2008, where you actually had the IRS planning to have an 80% level of service on the phones. You know, they worked through November 29th to get injured spouse duplicate returns processed, 1040Xs processed to get EIP payments out. And remember that the statute says that the advanced payment, no advanced payment will be made after December 31st, 2020. And the IRS will, I'm hoping they will announce what day it is that they actually have to cut it off, because there will be dead cycles toward the end of the year, and you would have to get your claims or your identity theft stuff processed by that date, or else you're going to have to wait until the filing season in 2021. So maybe we should talk a little bit about the litigation vehicles. And we got a question that was sort of a follow-up of the question. The question was about if you're a Social Security or a VA or SSI recipient and you didn't get into the portal, the non-filer portal, in time to claim your qualifying children by the April 22nd or the May 5th deadlines, could you now try to attempt to get the $500 for their kid, try to e-file through Free File, you know, et cetera, and see if you could get additional money? And the first thing is, you know, again, the IRS has taken the position that it's not going to issue to EIPs. And even though you could say, well, you didn't issue the EIP from the dependent, they're basically taking the position that they're not, the taxpayer got an EIP, and so we're not issuing another one. Now, that also goes to, I'm not sure whether you would be able to do anything electronically, because the IRS may have created on their records an electronic return in order to get the automatic payment out to the Social Security recipients, and that would block you doing something electronically, which brings us to the superseding return, which would have to be filed on paper, and that would essentially be a refund claim. And you would have to wait maybe 6 months, right, to, if the IRS didn't take any action on this thing because it's coming in paper. But that gets you very close to the end of the year, where the IRS won't be issuing any EIPs, you know, before you could get into court. So Keith, do you want to talk a little bit about some of the litigation that we've been talking about in terms of on the superseding return and raising some other issues?
Well, I think on the scenario that you just described, I'm not sure that litigation will help, because of the timing. By the time you have the 6 months pass and you have the right to bring the suit, and then you file the suit and the government had time to answer, you'd be in the filing season for 2020, and maybe getting your payment through filing a 2020 return would be faster than litigation. Somebody alluded to earlier the litigation that's been filed regarding children. So if a child has a Social Security number and would seem to be qualified to receive the EIP, and yet neither parent has an EIP, there's no mechanism in the system for them to get the EIP, because there can't be a return file that wouldn't have a disqualifying number on it. That litigation has begun in the District of Maryland. There's a few other types of litigation going on out there. The litigation involving children is very constitutionally based. So if you have an issue where somebody is not going to get a return, get a payment the way that it's structured currently, certainly there'd be no reason not to begin the process of setting that case up for litigation. If you have a situation that Nina was describing where you might not be able to get it as a practical matter during this stretch of stimulus payments, but you could get it in the filing season in 2020. You might find that just waiting to file a return is going to be the fastest, because everything is going to move so slowly before that. So the litigation is going to, whether you want to litigate an issue here, is going to depend on is it the kind of thing that you're likely never to get because of the way the IRS has interpreted, the way the Congress has written the law, or the IRS has interpreted the law, or if it's going to be a delayed payment where litigating is going to take you longer than just filing the 2020 return and getting it in the next filing season. Dina, I don't know if I answered the question you were asking, but that was kind of my take on the particular type of litigation that you were describing.
Yeah, I think, we've tried to think about ways to accelerate, but again, you're both dealing with there isn't anybody opening up paper right now, and then could you get the Taxpayer Advocate Service, for example, to accelerate the IRS's disallowance of a refund claim so that you could get into court longer than just waiting for the 6 months? But that's questionable whether you could actually accomplish that, on the basis of economic burden. The other thing that we've been thinking about, as Keith mentioned, looking at the categories, or in other areas, really looking at some of the pronouncements that the IRS has made, and seeing if there are vehicles to challenge it through the Administrative Procedure Act. What's your legal basis for making this statement? Or, again, the incarcerated individuals, what's your legal basis for just creating this out of whole cloth that they're not eligible? And working it through there. I think that these are really serious challenges here that we are sort of coming up against. I don't know, Nancy or Caleb, whether you want to weigh in on this? If not, we had a question about is there anything being done for individuals who have not received their EIP because their 2019 return is being audited? And I think that's a really great question. That's sort of something that I've been trying to make the point of, that there are lots of taxpayers that are caught up through the dependent database filters that their returns may have been referred over to exam, and there's nobody in exam going through them, or they're really backlogged to release the 2019 returns, which would not only release an EIP, but may release up to a $6,000 or more earned income credit payment, which would dwarf the EIP that's actually caught up there. And, that is something that's a major focus, I think, that needs to be a focus for all low-income taxpayer clinics and the IRS to really start turning now to getting through the inventory of, the cases that Josh has discussed, the pre-wage refund wage verification cases, and the cases that have been flagged by the dependent database that might involve EITC, where, if it's urgent to get dollars out to people, this is where our focus needs to be.
We've been getting some of these calls at our clinic as well, and I'm curious if you or Josh could tell us if that is something where it would be advisable to contact TAS, where because the taxpayer is under audit, that's the reason we're assuming they're not getting the EIP, and because as practitioners, we can't really communicate too much with the IRS or with exams. Is that something where TAS might be able to step in and do a little bit more than we are?
I mean, I think that if the primary issue is something that would come in under our criteria, then we would take that case in. My understanding is we'd take that case in, we'd work the audit issue, and then getting that audit issue resolved, would help get that EIP unlodged. So, I mean, I think that would be a viable option for those cases.
I do think that there is a case to be made for TAS taking in the EIP-only cases. It has a systemic advocacy function, and being able to track what is out there and the actual complaints that taxpayers have and the things that are going on, it would aid TAS. I also, wanted to note that these are, like I say, very challenging times. We're coming to the end of the program, and I want to thank all of the panelists for just the incredible job that they've done. I know we've probably raised as many questions as we've tried to answer, but we sort of knew that was going to happen at the beginning. And what we're really trying to do is get people to think about how to approach these issues, how to advocate on behalf of people. And the last thing I'd note is that, not being, since EITC documentation and stuff is being mailed in because all of this is being done through correspondence, the IRS needs to be able to focus on us being able to get information electronically to them for the lowest income taxpayers, just as they do for the largest corporations claiming NOL carryovers and things like that. So now I'll turn it back to the moderator to close up.
Thank you. And on behalf of the American Bar Association and the Section of Taxation, thank you for participating in this program. To learn more about the sponsors, visit the ABA website at americanbar.org. Thank you, and please click on the evaluation link. We value your feedback. For those of you who want CLE credit, please click on the link now appearing in the presentation window. This will open the program evaluation. After you submit the evaluation, the attendance confirmation form and request for CLE credit will appear. Please complete the information requested in the form and submit. Your information will be verified, and if your attendance meets all the requirements for CLE credit, your certificates will be emailed to you. Thank you and have a wonderful day.